Now I am going to dictate a legal passage at the rate of 100 words per minute based on Supreme Court judgment. Let's start. It was not disputed before the High Court that in an earlier proceeding the tenant had taken advantage of the provisions contained in subsection (2) of section 14 of the Act, that he committed another default in the payment of rent which covered the period from 1/6/1973 to 30/11/1973, and that it was then that a notice dated 14/12/1973 was served on him. The notice stated, para, your contractual tenancy in respect of house number A54 double story, KOLKATA, New Delhi 19 had already been terminated, whereafter you are a statutory tenant liable to pay damages for use and occupation at the rate of rupees 15 per month to me, that you have not paid the said damages after May 1973. In case you do not clear the arrears up to date within 2 months from the date of this notice, I shall be compelled to issue instructions to my legal advisor to file an application for your eviction ... number. Attempt to pay the rent was made in spite of the notice till the end of February 1974, although thereafter rent was remitted to the landlady through money orders, but she refused to accept the same and made an application to the controller for eviction of the tenant on the sole ground of a second default in the payment of rent. Both the controller and the tribunal in the appeal held that the notice was a valid one and that the expression damages for use and occupation contained therein meant nothing more or less than rent. In a second appeal, a learned single judge differed from the courts below and was of the opinion that the word rent and this said expression could not be taken to be 46 synonymous, and that there was no demand of rent in the notice in question, which did not therefore satisfy the requirements of the provisions contained in clause (a) above extracted. It is the judgment of the learned single judge which is assailed in the present appeal. Para. After hearing Mr. Vinod Bhagat, learned counsel for the appellant, we are of the opinion that the learned single judge has taken an unnecessarily hyper-technical view of the contents of the notice. It is significant that the notice specifically stated that on account of the termination of the tenancy by an earlier notice, the tenant had become what is popularly known as a statutory tenant, and it was in this context that a claim was made for damages for use and occupation at a rate equivalent to the agreed rent. We are of the opinion that in the circumstances of the case, the demand so made could not be construed as anything but a demand for rent. Consequently, the notice must be held to satisfy the requirements of clause (a) of subsection (1) of section 14 of the Act. Para. For the reasons stated above, We accept the appeal, set aside the impugned judgment and restore the orders of the controller and the tribunal. The case is remitted for further proceedings to the controller, who shall dispose of it within 3 months from the receipt of records from this court. No costs. Stop. Thank you.